Dear students, good morning. Today we will discuss about the recent Supreme Court judgment on role of governors. So we call this one as clarifying the constitutional roles, the Supreme Court observations on governors' powers. If you can see the main context for this case, in Tamil Nadu, we know that the government is DMK and the central government belongs to the BJP. So we know that governors are appointed by the central governments. So almost the governor is acting as an agent to the central government, even though the constitutional defined role is not that. But if you can come to the reality and if you can see the circumstances, most of the time these days governors are acting as an agents of the central government rather than acting as a friend and a philosopher of the state government, because this is the designated role of the governor. He should act as a friend and he should act as a philosopher. But if you can see the situations what happened in a chronological order, just we will begin with between January 2020 and April 2023. The Tamil Nadu governor B.K. Ravi, who is appointed by the central government, we know that the governors are appointed, and he withheld his assent for the 10 bills passed by the Tamil Nadu state legislatures between 2020 to 2023. If you observe the crux of those 10 bills, most of the bills, they are talking about the same thing. Most of the bills, I'm not saying every bill, but the crux of the bill is very similar. The bills want to curtail the governor's role as a chancellor of the state universities. So what is the intention of the Tamil Nadu government was, it want to appoint vice chancellors of universities of its own choice. But we know that the vice chancellors generally be selected through a procedure. Initially there is a search cum selection committee, and after that the government will finalize and will send those proposals to the governors. The governor will appoint the vice chancellors. This is the role. But these 10 bills are talking about different state universities have different all the state universities generally have a chancellor as a governor as a chancellor. So these bills tried to curtail the governor's role as a chancellor of state universities and transferring that power to appoint the vice chancellor to the state government. The state government wanted to appoint the chancellor rather than to be appointed by the governor. Now you may have a doubt that is there any constitutional provision which give authority to the governor as a chancellor of the state universities. But there is no provision in the Constitution of India that expressly makes the governor the chancellor of the state universities. Even the Poonch Commission also observed on center and state relations that there is no provision in the Constitution for the governor to act as a chancellor of that state universities. So this responsibility is assigned to the governor through the university acts which are enacted by the state governments. Broadly, we have UGC regulations. In that one, 7.3, if you can read it. Under regulation 7.3, the UGC empowers the chancellor, so usually the governor, to appoint the vice chancellors from a panel recommended by the search committee. So the search committee will be appointed. The search committee will recommend some of the names. The government will send those recommendations to the governor and the governor has to appoint. So the regulation 7.3 empowers the governor to appoint the vice chancellor. And if you can see the opinions of the different commissions and the different people on governor as a chancellor of universities, let us stick only to this issue because we have so many other recommendations as well on the role of the governor. But right now we are talking about governor as chancellor of universities. So if you can see that the Sarkaria Commission in 1983 to 1988, the Sarkaria Commission, it is advised that the governors should be avoid any statutory functions beyond the duties which is given by the constitution. So please don't give any other statutory functions to the governor. That is not recommendable. That's what the Sarkaria Commission told. Even the Punch Commission, the commission was there between 2017, that is also unequivocally recommended the governors should be relieved of non-constitutional and statutory rules, specifically their functions as a chancellor of the state universities, because this is creating a rift between the Raj Bhavan, that is the governor's office, and the elected government of the day. Even the Kothari Committee between 1964 to 66 and the National Knowledge Commission, these two committees also clearly recommended and they also cautioned against giving the academic governance powers to the governors, especially when they are appointed by the central governments, which means that it is undermining the university's autonomy and also undermining the state government's capacity to take certain decisions in the university administration matters. Now, let us see that what are the various options for the governors when the bill is presented to him. Now, what happened actually in Tamil Nadu? The bill was passed by the state legislature and it was submitted to the governor to take his assent so that the bill becomes a law. Under Article 200, when the bill is presented to the governor, there are three options for him. Number one, he simply give an assent to the bill so that the bill becomes the law. The second one is he can withhold his assent and return the bill. So currently, the Tamil Nadu governor is using this clause for most of his bills, most of the bills presented to him. So we know that the bills are two types, right? One is a money bill, the other one is a non-money bills. So whenever the non-money bill presented to the governor, according to the constitution, the governor can withhold his assent and return the bill as soon as possible. This is clearly mentioned in the constitution. As soon as possible. How? With suggestions for amendments. Because he has certain reservations about the bill, he is giving that these are my suggestions to make this bill much effective, and if you want to do it, please do it. And he has to do this exercise as soon as possible according to the constitution. If the legislature repasses the same bill, for example, whether with or without changes, the governor must then grant assent. So if again the bill was presented to the governor, initially the governor has returned the bill to the state legislature and he gave some suggestions, and the state governments may listen the suggestions, it may reject the suggestions, and if it is passing the bill again with or without amendments, this time the governor must give his assent to the bill. The third option is for the governor under Article 200 is he can reserve the bill for the president. When the bill will be reserved, in the governor view, if he feels that the bill which is presented to him will undermine the powers of the respective state high court, then he will ask for the president to go again on the bill and to give the opinion, so that the president consideration is important. So the governor, he will send his that particular bill to the president. So under Article 200 of the Constitution, the governor has three powers to him. One is giving the assent, the second one is withholding assent and returning, the third one is reserving for the president. Out of the 10 bills which is presented by the Tamil Nadu government, 5 bills actually it is with the governor. He is not withholding, he withhold his assent, and some of the bills are with the president. So 3 years of the time means really it is a very big timeline, because the constitution says that as soon as possible the governor has to return back the bills to the state legislature with some suggestions to him. So he did not do that. So that's why the state of Tamil Nadu, it went against to the governor of Tamil Nadu with the Supreme Court, because this is an issue of the center and state. So they directly approached the Supreme Court, and that case is State of Tamil Nadu versus Governor of Tamil Nadu. That they approached the court in 2023. The verdict came in 2025. So the Supreme Court judgment is very clear. So the Supreme Court said that the governor's decision to withhold assent to the 10 university related bills was absolutely illegal, and also it is erroneous. So that is a strong words used by the Supreme Court. And that those bills were deemed to have received an assent on the dates they were represented by the state legislature, because the Tamil Nadu state government already repassed the bills. So the Supreme Court says that on the day when Tamil Nadu government repassed the bills, from that day itself those bills are to be in the those bills are deemed to have an assent from the governor. That's what the Supreme Court said that. So the Supreme Court clearly observed different parameters under this one. Number one, deeming assent under Article 200. Now what is happening? The court clearly says that if the legislature repasses a non-money bill with or without amendment, the governor must grant his assent, and he cannot resort to withholding or reservation for a second time. So all the 10 bills which are presented to the Tamil Nadu Governor Ravi deemed to have received assent on 18th November 2023 itself, because on that day the representation was done. The second observation, no pocket veto should be exercised. So if the governor is not taking any call and he is simply withholding his assent, which means that under Article 200 he using his power as a pocket veto, because the Article 200 says that please take a call as soon as possible. This as soon as possible, the timeline was not mentioned in the constitution. So he is indirectly using a pocket veto. But the court says that it is a temporary deferral only. It will not come under absolute veto. So allowing governors to sit on the bills passed by the Legislative Assembly indefinitely would amount to a pocket veto. So which is incompatible with the parliamentary democracy. That is the second observation. The third observation is the judicial enforcement via Article 142. We know that Article 142 gives extreme powers to the Supreme Court to do a complete justice. The Supreme Court invoked its extraordinary powers under Article 142. It directed the bills be notified as law forthwith, underscoring the judicial ability to provide the complete justice when the constitutional rights are at stake. The fourth and final observation is the center-state balance. Even if you can see the recommendations of the Poonch Commission, Sarkaria Commission, they also clearly says that there is no point to involve the governor in certain kind of issues where his assent is not at all required. His presence is not at all required. So by eliminating the scope for indefinite withholding, the court reaffirmed the legislative primacy in state lawmaking, and it curtailed executive overreach in line with the recommendations of the Poonch and Sarkaria Commission. After that, the further consequences, the President Draupadi Murmu under Article 143 Clause 2, she has right to take the advisory from the Supreme Court, and she asked 14 critical questions to the Supreme Court, and the crux of the questions is very simple. Is the Supreme Court has the authority? Does the Supreme Court has the authority to direct the constitutional heads of the state and center, that is the President and the Governor, to do in certain way? So these questions we will discuss in the next class, but observe that those 14 questions crux is the same. Does the judiciary has authority to direct the President and Governor to do, to what to do? So those are the questions. So we will again discuss what are those 14 questions in our next video. Thank you.